Hello, I'm Ted Sabety, and today's talk is the IP Toolkit for Startups. Get started and get it right now. The thing about intellectual property is it provides you or your company the right to exclude others from copying the company's creativity that they want to imitate because they see its positive competitive effect in the marketplace. But this right has to be handled, and if it's mishandled, you lose that ability. And that is what we're going to discuss in the rest of this talk today. To download the IP Toolkit materials, go to our website, www.sabety.net. The first thing I want to do is go over the 4 basic types of intellectual property, so we're all talking about the same thing. The first thing I want to talk about is trade secrets and confidential information. Confidential information can start with what your business plan is, what the service is going to be that you offer, what that new device is going to be, the new product. The confidential information can grow into being trade secrets like your customer list, your finances, secret processes, source code, most importantly, personal information entrusted to you by your customers that has to be handled carefully. These are all examples of what's called confidential information. The second thing I want to talk about is copyrights. Now, copyrights cover things like graphics, music, text, audiovisual stuff. Copyrights don't protect ideas. They don't protect the functionality of a device or a piece of software. It does protect computer programs as text, but not the functionality. The third thing I want to talk about is trademarks. That's going to be anything like a logo or a word mark that denotes the source of goods or services. And the last thing is patents. They get a lot of attention in certain circles. And this is the regime that does protect the functionality of a device and the steps of a process. So let's turn to the slide, protecting confidential information with non-disclosure agreements. The most important thing to get from this talk is there's no one-size-fits-all non-disclosure agreement. Consider the kinds of confidential information your company is going to have. It has short-term confidential information, like what the product is going to look like. Once it's out in the public, it's not secret. It has longer-term trade secrets like proprietary source code or a secret process. And then, of course, there's very, very, very touchy confidential information like the personal information of your customers, where you're responsible for their privacy. These are all examples of confidential information that need different treatment under different kinds of NDA. Now, why do we have a mutual NDA? That's usually appropriate for the initial discussions of a business deal, and no one's going to disclose long-term or high-value information in that kind of a discussion. And so it protects both sides, that there are time limits and certain other covenants that are in there that make it effective for certain purposes, but not others. The thing to remember is your attorney's not going to be at that meeting. So you have to realize that when asked for sensitive information beyond short-term business plan type stuff, you need to ask the other side to sign your unilateral non-disclosure agreement in order to be in a position to make those disclosures safely. So you see the context for the mutual NDA is different than a stronger unidirectional NDA with a business partner. Now, with regard to employees, they too can have a strong NDA because they're going to be privy to some very confidential information in your company. This could include source code. It could include the personal information of your customers that you're responsible for. And for this reason, it's important to make sure you have those agreements in place and signed and on file. So you see, there are several different flavors of non-disclosure agreement that apply to different business contexts. The second thing I want to talk about is your trademark. All businesses have some kind of a brand. A big takeaway here is you need to clear your brand before you start using it. Getting A URL is not establishing your exclusive right in that trademark. The reality is somebody else may in fact own the trademark that covers the URL that you purchased. And we've often been involved in those disputes. So the most important thing is when you're selecting a brand and you decide you want to invest in it, you need to get a clearance from an attorney who has studied the situation and determined that your use of that trademark will not infringe a senior similar mark. The accidental use of someone else's brand can result in some very expensive rebranding efforts for the company, as well as legal liability. A Google search is not a complete clearance. Just because the senior owner of the trademark didn't come up in the first page of hits doesn't mean the trademark is clear to use. Now, cheap trademark filing services on the internet don't provide a proper clearance. And the reason they don't is because they're cheap, which means they're not putting the effort in to provide you a proper clearance. If they did, they wouldn't be cheap. The other thing that's important regarding trademarks is that time is not on your side. You want to reserve the cleared brand by filing an intent to use application for trademark registration. That establishes a date where you do start to have some rights over the trademark even prior to using it in commerce on your product or service. Filing early is also recommended because we found that branding ideas are like memes. Other people may come up with the same idea at about the same time because it has to do with our culture. And you want to be the first to file. Note that the use of your trademark on Delaware filings that incorporated your company is not sufficient to establish exclusive rights in your trademark. It's the use of the trademark on the branded product or service itself, except in the case of the intent to use application. So that's why it's part of our toolkit. So let's now turn to copyrights. Now, copyrights, as I said, are things like graphics and text and words in a book, music, videos, computer source code, object code, the appearance of the user interface. A lot of times companies think that, well, I paid somebody to create this, so therefore we own it. Maybe. It depends. A lot of people say, well, they signed a work for hire agreement. That particular phrase is bandied about and not particularly accurately. The doctrine of work for hire applies to true employees of a company and doesn't apply to a contractor except in a subtle way in the context of an intellectual property assignment. Because of these legal wrinkles, what you want is an intellectual property assignment that says all the intellectual property in the work product I create during my engagement with the company is hereby assigned to the company. So typically when you have an employer contractor who are building program code, website code, graphics, logos, audio, video, text, even fashion designs, things of that nature, you want to have an intellectual property assignment document signed by the person that really conveys title in the intellectual property to the company. And it can be combined into the document that has the employee or contractor non-disclosure agreement. Now, copyright registration is not required in order for there to be a copyright. However, copyright infringement damages can only be collected for the infringement that occurred on or after the date of registration. So the general recommendation is to file a copyright registration on publicly displayed copyrightable materials. Let's turn now to patents. Patents are a bit more complicated, but let's make it easy. The first thing to understand is a patent gives you the right to exclude others from making, using, or selling some new kind of technology, either as a result of it being a patented process or a patented device. But the inventor is the question. If somebody has invented the patent, how does your company own it? They own it by means of an intellectual property assignment. So you're going to want to get this intellectual property assignment from employees and contractors who are inventing new technology for you. And that can be combined with the employee contractor NDA. And we even do this in the case of product designers who are making aesthetic creations for the appearance of a product, because part of the patent regime, besides technology, includes the ornamental appearance of a product. And we call that a design patent. Now, the big takeaway here is that you can't get a patent over what they call the prior art. And that's anything that's happened before you filed your application. So one of the important things to avoid is making your own product part of the prior art, or your own product announcement, or your own white paper you stuck on the website. So generally what we recommend is filing the application before any commercialization. Now, there is this 1-year grace period, but my recommendation is if you can plan ahead and not rely on it, that's the better practice. Now, the other reason that time is not on your side with patents is that prior art includes what other people are doing. So in a fast-moving field, you have to be concerned about getting a filing date before your competitor files or publishes an article or some white paper describing what your invention is. So the real rule here is file early and file often. Now, here's another pitfall. A provisional patent application is not a patent. I don't know how many times I've heard people say, oh, no, we've got a provisional patent over that. It doesn't mean anything. All it is a filing date for only what it discloses, and it expires in a year if it isn't followed by an actual application. But here's another issue. It only has a filing date for that which was specifically disclosed in the provisional application. The problem is, if you go to a cheap website to get a provisional patent application filed for $100, if it's not sufficiently detailed, like a proper patent application prepared by an attorney, you may find that your own commercialization becomes prior art to the later filing date that applies to the later application where the detail was actually provided. This means that any claim in that later application may be invalid or not patentable over your own commercialization. That's a big problem. So let's wrap up today's discussion and talk about the Startup IP Toolkit. There are 4 components. There's a mutual non-disclosure agreement for discussions between parties when they're talking about short duration trade secrets that are not particularly sensitive. There's a stronger unidirectional non-disclosure agreement to be used with important trade secrets like source code, personal information, customer lists, things of that nature. There's an employee contractor intellectual property assignment that contains non-disclosure covenants. This is a document you need to have every employee and contractor sign and maintain these signatures on file. We also include our Startup IP checklist to assist you in organizing the materials you need in order to properly work with an IP attorney in the furtherance of your business objectives. To get your Startup IP checklist, come to our website, www.sabety.net, and on the homepage is a registration link where you can download these materials. Please note, every situation is different. Before you rely on any of these documents, you need to get proper legal advice to make sure the document is going to work for you in your specific situation. Thank you very much. If you have any questions, let us know, and I look forward to hearing from you.